First of all, I want to thank everybody for taking the time and joining us this morning. My name's Paul Aldrich. I am the Safety Director for Group Management Services. In the spirit of, there's probably going to be some questions, and, this is a pretty important topic. We're going to just jump right in. Today, we're going to talk a little bit about what to do when OSHA knocks on the door. I've been around a long time. As far as group management services is concerned, we have, 3 to 4 OSHA incidents that happen on a monthly basis. So I'm not to say we're OSHA experts, but I am going to say that we do know a lot when it comes to what to do if OSHA does happen to knock on the door. We'll talk a little bit about the background, preparing for an OSHA visits, reason OSHA is going to knock, knowing your rights, what's OSHA going to ask for. We're going to talk about the opening conference. We'll talk about the inspection itself, closing conference when OSHA is wrapping things up at your facility, and what to do when we receive our violations in the closing conference and the informal conference. So a little bit of background on OSHA. They were established in 1971. Prior to that, obviously, employers went unchecked, and there was quite a few injuries. Not taking care of your employees, no safety requirements, steel workers on the top of the Empire State Building. Everybody is very familiar with that very famous picture with all those workers sitting there eating lunch on a scaffolding or on a beam, 80 stories in the air. So those are the kinds of things that, OSHA was established for, is just because, the government decided that they needed to step in and do something because of the amount of fatalities that were happening every year. They did cut those injuries by 60%. So, everybody, when you sit there and talk about an OSHA experience, if I talk to any employer that's ever had OSHA knock on their door, the very first thing they're going to say is, it's most certainly not going to be, oh my God, it was amazing. It was the best experience I ever had. So, it's something that is stressful to a small employer, small company. A lot of the times, the very first thing I hear from one of my smaller clients, 10 or less employees, the very first thing they're worried about is losing their business. I can assure you, with our help, one, you're not going to lose your business. OSHA is not looking to shut companies down unless you guys are, swinging around on a rooftop with absolutely no fall protection whatsoever. So if you're blatantly putting your employees in a dangerous situation, then, maybe, you deserve to be shut down at that point. But as far as group management's concerned, all of our clients, everyone I have ever encountered, I've been here for 6 years now, everybody is very concerned about making sure their employees are safe. And they're very active. And the fact that you guys are tuning in today, whomever you are, just shows the fact that you do care about your employees, and you want to make sure you're doing everything you can to keep them safe. And of course, you're concerned about, hey, what is it that I do if OSHA does knock on the door? So I'll go ahead and read this slide real quick, and that's not what I'm going to do throughout. I'm going to just be able to talk you through things. But since OSHA's establishment in 1971, workplace fatalities have been cut by 60%, and occupational injury and illness rates by 40%. At the same time, the U.S. employment has nearly doubled from 56 million workers to 3.5 million worksite employees, 105 million workers at nearly 6 million million sites. So what are we going to do to prepare when OSHA comes knocking on the door? First of all, first and foremost, you want to make sure that you always have a competent person on site. Now, there's always questions. Okay, what is a competent person? does the competent person need a license to say that they're a competent person? The answer to that is no. If you own a company and you've had Mike working for you for 15 years, and you know he's able to recognize a hazard and eliminate that hazard, or use PPE to help prevent any injuries, to skirt that hazard, then he is a competent person. So that basically, as far as a competent person is considered, is you appoint that competent person, and that is all that OSHA requires. Train your employees, obviously. So if you have whatever hazards that you're exposing your employees to on a day-to-day basis, OSHA requires that you have a training or a refresher course yearly on those hazards. Now, there are some things that, you can, as far as like you can say, well, forklift training, that's every 3 years, which is true. So every 3 years you can, they have to be certified to operate the tow motor. And they have to go through that training every 3 years to update that certification. And it is a law that they be certified on forklifts. If any questions, so I'll go back just a little bit. If anybody has any questions, just please submit them on the chat, and then I'll stop every little bit between slides and answer questions that you might have that you've thought about, and I'll do that quite often through this whole presentation. Again, training your employees on any hazard that they might encounter on a day-to-day basis. Have a plan. And that's in any time and everywhere. What I mentioned is what GMS is really going to walk you through. We're here to make you compliant and help you put that plan together. So having a plan is simply knowing what to do. If OSHA does knock on the door, we're going to sit them down and we're going to call GMS. So we'll talk a little bit more about this later in the presentation, but have a plan. And don't be intimidated. Don't be scared. After everything is said and done and you get GMS involved to help you put that plan together and help you become compliant with making sure your safety manual is in place, making sure you're doing your OSHA 300 logs, making sure that you have an SDS book and then it's up to date, making sure you have training logs. OSHA loves a paper trail. They love to see everything in writing. If you have it on your laptop, that's good as well, or on tablets, that's also good. A lot of our clients, will have, their SDS sheets on a tablet instead of in a book, and that sometimes is better because you can reference those really quickly, and making sure your employees understand what is that SDS sheet anyway? Why is it important? So training on everything to make sure your employees understand what they're looking at is all in preparation for what happens if OSHA does knock on the door. And preparation is key, and being compliant is key. And you know what you know, and I can, I go see clients quite often. And most of the times they were like, oh, what is an SDS book, or what is that? And we're going to help you through those things. A lot of times they might not even have heard of a 300 log. So if you haven't, then we're going to help you and walk you through and tell you why that's important. With that being said, reasons OSHA is going to come knocking. A compliance officer is, they must stop if they see open trenches. Or if they see an imminently dangerous situation. So if they're driving down the road and they see open trenches, they have to stop. They're ordered to. That's in their creed. I did cell phone towers for a living, and I was the civil guy, and I would be digging, trenches every single day. I had compliance officers stop on a fairly consistent basis. And really, you answer their questions, and the first order of business is as soon as the minute they walk on your site, The most important thing is to find out why they're there and get them off, right? Get them out of there. And that's where GMS is going to come in as well. But so I digress. So the reason OSHA is going to come, one, they are driving down the road, they see an imminently dangerous situation, they are going to stop. Of course, if there is a major injury and or, knock on wood, a fatality on one of your sites, you're going to see OSHA come and conduct an investigation after you report that injury. A verbal complaint. So this is the big unknown. This is 80% of the reason why OSHA is going to come knocking on your door. Is you have either a disgruntled employee or an employee that thinks that you're putting him or her into a situation that is a dangerous situation. So again, the fear of the unknown, that is the biggest thing. That verbal complaint, that disgruntled employee calling OSHA, that is 80% of why they come. Now, just on that point, we get calls, like I said, we'll do 4 to 6 OSHA related incidents every month here at GMS, sometimes more. And when you do have an employee complaint, you will get a phone call from OSHA 100% of the time. They are obligated to call on any verbal complaint from an employee. So you will hear from OSHA. Now, 99.9% of the time, they're going to call unless they think that they really have to get out there because this is really something super serious, like, an unguarded, 6-foot, saw blade or something along those lines. But most of the time, you're going to get a phone call from OSHA. And when you get that phone call, they're going to ask some questions, and they're going to also request some pictures and proof that, one, this hazard, if it does exist, that it's been taken care of, or you're proving the fact that he was just a disgruntled employee making things up. So they're going to ask for some proof, and they're going to give you those 15 days to comply, and that's kind of a magic number with them, the 15-day deadline in order to comply. We'll talk a little bit more about that further on in my presentation. And random inspections. So, once a year, OSHA will sit down and they'll talk about, okay, we had a lot of reports from general industries on unguarded equipment. So you might just get an OSHA compliance officer come and knock and say, hey, by the way, my name is, John, and I am with the OSHA, and I'm a compliance officer, and I'm here to do a random inspection. In any of those cases, that's why they're going to knock. So know your rights. If they do come knocking on your door, you have that right to say, hey, by the way, go away. we are refusing the fact that we want to let you in to do this inspection. You do have that right. I would suggest you do not pull that card. Because they will get a warrant and they will be back, and they will be back with a magnifying glass. So when they do come to the door, the very first thing you're going to do is ask the reason why they're knocking, of course, and they've already stated that they're there to do a random inspection. In that case, the very first thing you're going to do is you're going to call GMS, call one of us, call me, call your account manager, get a hold of somebody ASAP, and let us know that you have a compliance officer at your facility. I will have somebody out there within the hour. Now, if I, for some reason, cannot get somebody out there within an hour, which I have not come across unless we've had our clients out of the state of Ohio. I have a gentleman down in Cincinnati. I have a gentleman in Columbus, and I have 3 coordinators here in Richfield. So we'll be able to get to you within an hour, pretty much anywhere in Ohio. Now, sometimes it might be a little over an hour, but with that being said, if they do knock, you can tell them, hey, I've called my third-party group management services, and they are on their way. There's a coffee shop across the street. I have a lunchroom that you can sit in, and we have Wi-Fi available. And they will wait. They'll wait. I've had them wait up to about an hour and 15 hour and 20 minutes for us to arrive, and then we'll go from there. Now, for any reason, we cannot be there, and I cannot make it. We want to make sure that we have somebody walking with that compliance officer on his investigation or on his walkthrough. Again, try to limit him, but if they're showing up for a random inspection, they pretty much have carte blanche to walk through your facility. Again, if you do have, if we're not able to come, you have a competent person walking with that compliance officer, asking questions, a lot of questions, as far as, why are you taking that picture? Is that something that I can take care of right now? So if the compliance officer comes and he sees an open electrical panel, that's a $2,500 fine right out of the gate. Now, 7 times out of 10, he'll let you close that and let you know that, hey, that's a violation. I'm not going to cite you on that, but make sure in the future that doesn't happen. But then you're going to get that compliance officer saying, hey, basically, that was a violation, and I'm going to fine you for that, regardless of whether or not you go up and close it. Again, I'm going to tell you right now that, we as coordinators here at Group Management Services are not OSHA experts. OSHA is going to walk through a facility right after I walk through a facility and more than likely find something that I did not. But the bottom line is we're going to be able to, knock out a very good percentage of any violations you do have. If you don't have anyone available to walk through with that employee, with that compliance officer, send your next senior guy. If you don't have a manager, you go yourself. You want to make sure somebody is with that officer. And again, any picture that they take, you take. And a little bit more on that is, don't offer any information. Don't, when I say, ask a lot of questions, ask questions when they're taking a picture. Ask questions if they're looking at something and taking a note. You're going to want to know what are you writing down. And they're going to tell you. They're going to be above board, honest, and open on anything they write down and any picture they're taking. Compliance officers, they might be strict. You might not say, hey, let's go have a beer after work today, but they're reasonable, and they will tell you. They have to tell you and be 100% above board when it comes to anything that they find as far as the walkthrough through your facility. Yes, so anything that they say they can cite. So again, if we have an injury that takes place in our facility, let's say that somebody was working on a machine and was somehow caught up in that machine and sustained an injury that either they had an amputation or they were admitted into the hospital. The OSHA compliance officer is going to want to see that machine. When we take that compliance officer to that machine, we're going to take the most direct route we possibly can and let them see as little of our facility as possible. And that's why it's so important to get GMS involved. So I've had an injury that happened way far back in the warehouse or in the facility, and instead of walking through the entire facility, we walked through the parking lot, around the back of the facility, into the door nearest to where that injury happened. Now, there has been times, and I've had a long conversation with some compliance officers on a day like today. The snow is blowing, the wind chill factor is down below 0. He might say, hey, listen, I'm going to put my blinders on. Please don't take me around the whole parking lot to the back of the building, to that door that's nearest to the injury site. They will say they're going to put their head down, and then they're going to walk to that site, and I'm going to hold them to that, and that has happened before. So again, know your rights and understand and make sure you ask a lot of questions in that particular case. The opening conference, again, when that OSHA compliance officer shows up, they will give you their credentials. They're going to tell you who they are, and they're going to tell you why they're there. You're going to find out why they're there, but they're going to basically, in that opening conference, they're going to really go through. They have their own script that they're going to follow as far as the opening conference is concerned. You're going to know exactly why they're there. And they're going to tell you what they're going to be expecting to do. They're going to tell you what they're looking for. They're also going to tell you anything they see they can cite. So again, if you're taking them somewhere, make sure you take them the quickest way to get to wherever you are going. Get as much information as you can without offering any information. What do I mean by that? What I mean is, don't tell a story. Don't be like, well, yeah, this one time that we did have, this one machine, we just decided to unplug it because it wasn't guarded properly. There's a lot of problems with that, and he's going to ask a lot of questions, and you're just going to dig yourself in a hole that you just don't want to be in. So again, don't offer anything. Answer any questions and answer them above board. Don't lie. Don't fabricate. Don't butter things up. If they ask you, as hard as it might be, if they ask you, was this employee trained on this particular piece of equipment? If you do not have anything to back up that training, don't say, yeah, we told him all about it. Because that compliance officer will interview that employee, and you're just going to get yourself into a heap of trouble. And it's not going to bode well, especially when it comes to the closing conference and the informal conference. Again, get as much information as you can. And again, the first thing we want to do if OSHA does show up on site, like I mentioned a little earlier in the presentation, the minute they show up, the first thing we want to do is get them off the site. We don't want them there. So we're going to do our very best to make sure they're there for as little time as possible. And that's, our job. But if we're not there, that's going to be your main motivation. Find out why they're there. Let them see what they want to see, and get them out of there. Again, always be above board. And don't offer any information. I can't state that enough. As far as talking to a compliance officer, some people are, and they just walk into trouble when they start talking about, their business. Now, this is something that you're very passionate in, and there's things that you might want to tell the compliance officer. I've been so safe, and I haven't had an injury in the last 5 years. And you start telling a story, they're going to be asking questions, and you might just say something that you regret later. So again, only answer questions. Don't offer any information. All right. What's OSHA going to ask for when they do knock? Now, they might ask for more than what's on this list, but be assured that they're going to ask you for the things that are on this list. They're going to ask for an updated safety manual. They're going to ask you for any safety inspections that you've done, walkthroughs, in the last 60 days and or more. They're going to ask you for assignments for your employees. They'll also ask for a hazard communication. They're going to ask for some employee training records. So any kind of training that you've done in the past for your employees, they're going to want to see that. They're going to want to see your material chemical safety data sheets, the SDS sheets. Injury and illness summary backdate 3 calendar years. Those are your 300 logs. They're going to ask for those. And any documentation related to an inspection, training logs, written programs, equipment maintenance logs. So that's another thing that Group Management Services offers, obviously, is going to be that risk assessment walkthrough. The first one that we do for you, if you're a new client, or even if you've been with us for a while and maybe didn't know that, safety existed or didn't think you needed safety in the past, that very first risk assessment we will do at no charge to you. And those are very important, those inspections, those risk assessments. After one of my coordinators conducts a risk assessment, they will also send an email with their findings and their recommendations. And their recommendations are going to be, you need to do certain things as far as training is concerned. You need to do some forklift training, fall protection, things of that nature. And one of the biggest things that, especially in a general industry setting, that OSHA is going to be asking for is going to be the fall protection part. Anything above 4 feet in the general industry world, you need fall protection. Does that mean if you're on a step ladder, do you need fall protection? No. But I've walked through many facilities. The one facility I walked through, they do maintenance on large equipment. They buy old, antiquated equipment, and they refurbish that equipment. One of our clients, they refurbish the equipment and resell it. Some of the equipment stands, 10, 15, 18 feet tall, and they need to get on top of that piece of equipment sometimes and paint or add guarding or whatever the case may be. The minute that their feet leave as soon as they're 4 feet or higher on that piece of equipment, if they're painting it or if they're on top of it, if they're dusting it, whatever the case may be, then they are required to wear fall protection. And a lot of times, we're going to help you find a way to make sure that they are safe and they are wearing the fall protection. So sometimes, you might it might cost you a little money in order to get a piece of equipment that is a fall arrest system, because, this piece of equipment's in the middle of your warehouse, and there's really no other way to get on it unless you crawl on it, right, and get on top of it. And that's where that portable fall protection unit might come into play. And again, that's another reason why GMS can help as far as, hey, here's a hazard and here's how you avoid that with PPE, proper PPE, personal protective equipment. So that is the last resort, the PPE. So, a lot of companies will buy those ladder units on wheels to where there's a railing at the top of the ladder unit with a working walking surface, and they can do most of their maintenance right from the top of that unit. Again, as long as there's railings, you don't need the fall protection, but because that acts as fall protection. But we want to make sure that we're doing things the right way as far as those things are concerned. What are we going to do during the inspection? Again, if it is an OSHA complaint or it's an employee that called, make sure you obtain a copy of the complaint. Again, as far as the that compliance officer, again, you want to limit them, their exposure to whatever is in your warehouse. You want to make sure you establish boundaries and stay in the boundaries in that opening conference. So he might say, okay, I'm here to investigate the injury that happened on this particular lathe. Again, we want to make sure that we're limiting that compliance officer to what he sees. I did a recent inspection for an orchard. As a matter of fact, it was an apple orchard, and they had a lot of equipment that packs the apples, that crates the apples, and somebody was injured. And they had a lot of overhead doors, like garage doors, that separated portions of their facility. Basically, I just had them close all those other garage doors, and we took that compliance officer around the door that was closest to the unit where the injury occurred, to limit that compliance officer's field of view as far as what they're looking at. Again, if the compliance officer is walking through your facility, we're going to try to eliminate any violation on the spot. So if he or she sees anything, a lot of times in that opening conference, you could say, hey, if you see something, are you going to let me, if I bring a maintenance guy along with us and it's something that can be fixed on the spot, will you allow that without any violations? And they'll let you know right then and there. That's not necessary. If I see a violation, I'm going to cite it. I can't tell you how often that's going to be, but there are some compliance officers out there that are like, yeah, that's no problem. So again, eliminate that violation on the spot with a maintenance person if that's applicable and the compliance officer allows it. You're going to want to take detailed notes. We'll be doing that. If we're there, we're going to be taking detailed notes. Any picture that compliance officer takes, we're going to take the same picture, ask questions, just so we know when it comes to fixing any violations, we have a record of it. If they take a picture, you want to take the same picture. All right, so after that opening conference, after the inspector walks through the facility, then they are going to have a closing conference. They're required to conduct this closing conference. At the closing conference, they're going to tell you, what they saw. They're going to tell you what you can expect as far as violations are concerned. They will definitely share everything that they are going to be citing you on. And then again, those are just things that we're just going to want to make sure we take note and we address immediately. So, for example, if we accompany a compliance officer walking through a facility and he's doing the closing conference and he brings up, the lack of fall protection training, we are going to set up a fall protection training, obviously. We might do it that day right there on the spot. We might, do it the next day. But we have 15 days from when we receive his violations. And I'll go over that in a second. The officer will discuss possible course of action, which could include the informal conference where you can contest citations. So in every single when OSHA does knock on the door and they do come to your facility, you can expect to see some violations. Now, I recently did, we had a gentleman lose a finger recently between two prefabricated concrete walls when they were putting them on the flatbed semi-trailer. He was guiding one of the injured employee was guiding one of the walls into place, and his finger was caught between two, 6,000-pound pieces of concrete, and he lost his finger. When the OSHA compliance officer came to do his inspection and we walked through the whole process, he left there saying that he was not going to be sending out any violations. It was the employee just, tried to stop, 6,000 pounds from moving, and he knew better than to do that. He was trained not to do that. He even stated the fact that he knew that it was just one of those reactions that he wished he didn't have. And the compliance officer, saw that and left there and sent the employer a letter saying that they weren't going to have any violations. So that was a win on our part, and that's why it's so important to get group management services involved in any OSHA related incident at your facility. One, we know what we're doing. We know what they're looking for as far as compliance officer is concerned. And we want to make sure that, they understand that, we did everything to prevent that injury. So in that particular case, we walked away with no violations. There also, we could receive a rapid response letter as well. And we've received quite a few of these in my tenure. I've been here, like I said, 6 years. And over those 6 years, I've received no less than 20 rapid response letters, and basically those letters result in an investigation that the compliance officer felt that we were doing everything that we could do to keep our employees safe. Our trainings were up to date. Our everything was in order, and they were going to, drop the investigation without any further violations. So those are really good letters to receive, and that's our goal. Again, is to get that rapid response letter. We had a gentleman. The one that sticks out in my head is it was a landscape company, and there was a worker who delivered some mulch, and after putting the bed back down after delivering the mulch, he jumped up into the back of the dump truck and was sweeping out any excess mulch that was in there. He put his broom down, and then he put his left hand on the top of the truck, and he had about a 4.5 foot jump to the bottom. And by the time that his weight grabbed, his wedding ring stuck on the top of the truck, and that wedding ring acted like a samurai sword and cut his finger off, and his finger remained on the top of that truck. And the actions we took, so we had to report that. So we called and reported that we had an amputation. And then the compliance officer asked us to send our investigation and our recommendations and our trainings and everything in the what was the reason for the injury, and how are we going to prevent that injury from happening again, right? They want the root cause, and they want to make sure it doesn't repeat itself. So the things that we put in place is, we issued all the employees that needed to wear their wedding ring or their wife would leave them. We issued rubber rings to everybody that was married, so that no longer was a hazard. We also made sure we welded steps to the sides of the dump truck. And we were not allowing anybody in the back of any dump truck that didn't have access to the back of the dump truck via welded ladders to the side of the truck. So after they received all of our, the root cause and what we did to prevent the injury from happening again, they did send us a rapid response letter without even investigating an amputation, which again is pretty much unheard of. So those are the things we're going to do to make sure that we keep OSHA out of your facility. And again, it's funny that, this morning even I had our internal lawyer came up to me with some questions on an anchor point as far as OSHA was concerned. Again, we came to the conclusion that, there's some not myths, but an anchor point needs to be it needs to withstand 5,000 pounds or 2 times its intended load. So what that means is if an employee falls, there's going to be more than that employee's weight because of the sudden stop, right? So there's some math involved, but the bottom line is it doesn't have to necessarily be 5,000 pounds. And that was the question. So again, we're very versed in OSHA guidelines, and I deal with it almost on a daily basis as far as questions go, as far as OSHA is concerned. I do want to talk a little bit about a lot of questions on temporary employees. So this is very importantly in that you pay very close attention to what I'm going to say now as far as your temporary employees are concerned. I don't know the agency in which you use. There's hundreds of agencies in Ohio that supply temporary employees. So I'm going to read these 3 paragraphs I have, and then we'll go and explain these a little bit. And Leanne, if you have any questions, again, make sure you're submitting those to Andrew, and I'll answer them for you. The question is, if I obtain employees from a temporary help service, employee leasing service, or a personal supply service, do I have to record an injury or illness occurring to one of those employees? The answer is yes. You must record these injuries and illnesses. If supervise these employees on a day-to-day basis, that means they need to go on your 300 log. So if you're utilizing temporary workers as a company supervising these employees, you are responsible for maintaining any recordable injuries on your 300 logs. As the company supervising the temporary worker, you are required to ensure that they are trained on the hazards present at the job that they are performing. So again, it's pretty much it's fairly simple as far as you're going to be responsible for that employee. Now, does that temporary agency have some skin in the game? The answer is yes. You guys are sharing that responsibility. So if I owned a temporary agency and I am giving that temporary employee to you to work for you, I am responsible to make sure that employee is getting properly trained. So if I were a temporary agency, I would probably ask for your written safety program. I would ask, how often do you get training? Are you going to train my temporary employee? If you are going to train my temporary employee, I want to see those trainings. So I don't want to get too far into what the agency should do. I want to focus on you as the employer who is getting that temporary employee. Again, if that temporary employee does get injured, you are responsible to put that on your 300 log. And if there is a reportable OSHA incident with that employee, you are responsible to make that phone call to OSHA to say that there was an injury. Now, they are going to come to your facility and all of these other things are going to apply. Now, when it comes to sharing responsibility and accountability, it's going to be up to that compliance officer on how they want to take that and how they want to issue those fines. Now, if you as an employer can prove that you've done all the training and that's going to be the key part of it. If you have 10 or more employees, so if you have 9 employees, you do not have to fill out the 300 logs. Now, at any point during the year, so let's say on December 1st, you hired your 10th employee, then you need to fill out 300 logs for that calendar year. But with 9 or less employees, you do not have to fill out a 300 log. 10 or more, you do. If you do have more than 20 employees, then you have to electronically submit those 300 logs. And with that and the 300 logs, I do want to say that, GMS and our coordinators will assist in helping you with those 300 logs. They will train you and let you know exactly what to do. The way to do it is if you get an injury, you want to put it on that 300 log when it's fresh. Don't wait to the end of the year and then go back and then fill out your 300 logs. Fill those 300 logs out and be proactive with them. If you are on payroll, you count. If you're collecting a W-2 and you're on payroll, then you count towards that. Now there are a lot of owners that do not take and are not on the payroll. Then you do not have to count yourself. But if you are on the payroll, then you count towards that 10 employee mark. Andrew, I don't want to go and misspeak here. You said yesterday you found out what about the 20 employees?
Yeah. So just to bring that back full circle there for everybody, if you do have 20 or more employees, you do still have to report those 300 logs electronically. There was a change that Paul was referencing, and that's to employers with 100 or more employees. You do have to send in your 301s for each injury, and that's for employers in specific NAICS codes or NAICS codes with high hazard.
And again, as far as electronically submitting those, they make it very easy to do so. That doesn't put you on any kind of red flag radar. There are 20,000 small businesses in Ohio. And again, imagine how many there are throughout the United States as far as electronically submitting their logs. That is just going to be a reference to, again, if OSHA does knock on the door, if you have 20 or more employees, they should already have your 300 logs recorded. So that is nothing that needs to be concerning. It's not like, hey, if I electronically submit these, I'm opening myself up for an inspection. That is absolutely false. It is just another matter of reporting your 300 logs. Again, Andrew will send out that link. And if there's any further questions on 300 logs, please don't hesitate to get a hold of your safety coordinator. So again, call your account manager, ask who is assigned to your company to start asking specific questions, not only on the 300 log, but just on trainings and safety in general. I require my coordinators to do a minimum of 40 visits a month. So needless to say, they are very busy, but they are very willing to help. And
we do have just a quick question here, comes from Luke Edmonds. If you'd like to address this, if we would rather submit the electronic or would rather submit the 300 logs electronically, can we do that? I believe the answer is no, but if you'd like to address
if you have less than 20 employees, then no. Because the whole walking you through the whole electronically submitting process will eliminate it. It'll just exclude you from being able to report that if you don't reach the requirement that they're asking for.
And perhaps maybe the question is more along the lines of filling them out electronically. These forms are available as PDF packages, and you can certainly fill them out and type them out. And then print and post them. But yeah, if you have less than 20 employees, you don't want to electronically file them to OSHA. They'll basically come back and tell you you didn't need to do that, and have a great day.
Receiving citations and the informal conference. So if you do receive citations, you have 15 days to reply to those citations. Now you can pay them. And they will tell you right there what those citations are, how much they are, and what to do if you just want to go ahead and pay them. Always talk to your coordinator. I will definitely tell you to schedule an informal conference 99% of the time. But if you had a major injury and you're looking at a $2,500 fine, I would probably recommend paying that $2,500 not to open yourself up to anything else in the future. Now, when you do receive those citations, if they're serious citations, we definitely want to address those. We want to get those serious citations. We want to get them reduced to other than serious. The reason for that is if you have another serious citation that is the same as the citation you've already received, then you're opening a whole new can of worms, and the fines could get exponential up to $140,000. So again, when you receive those citations, we have 15 working days in the receipt of the citation to respond and to schedule that informal conference. Obviously, that there are lots of advantages to the informal conference. Our success rate is rather high, and we have success in reducing those violations from 50 to 60% in the informal conference. I could tell stories. I just don't have time right now. But again, the informal conference is very important. Timeframes are very important as well. So do not sit on any violations that you receive from OSHA. Do not sit on any phone calls. Make sure that we're very, very proactive when it comes to responding to OSHA. And again, those 15 days are very important. Now, I'm going to go over really quickly on a reportable injury. A reportable injury is a amputation a loss of an eye, admittance into the hospital, or a fatality. Those are the 4 reasons we're going to have to report to OSHA. Now, when it comes to an amputation, that is real simple. You get the paperwork back from the office or from the hospital, and if anywhere on that report back from the hospital, injury report back from the hospital, if it states that there was an amputation, it automatically makes that a reportable injury. No questions about it. Even if it's just the tip, if it says a partial amputation of the left finger, then it is reportable. So don't misconstrue that. Now, where things come into play is we've had a gentleman fall from heights. He was knocked unconscious. He was rushed to the hospital. He regained consciousness at the hospital. They did not find any brain bleeds. They didn't find anything other than the fact that he was knocked unconscious, and they kept him overnight for observation. That is not reportable. We do not need to report that. That is why it's so important to get group management services involved, so we can distinguish whether or not this is a reportable injury. I've had a lot of injuries that people are like, oh my gosh, we have to report this, and it turns out it wasn't reportable. So very, very, very important that you get GMS involved when it comes to anything as far as an injury is concerned. If you're not already receiving our monthly emails, here is and I'm gonna again, I will send this PowerPoint to Andrew, and Andrew will forward this to anybody that was on the presentation today. You will receive this. Here's something. This is an easy way to join our mailing list here at GMS if you're not already receiving monthly emails. Oops. Again, how can GMS help? It's the bottom line is get us involved. We can help with creating, updating your safety manual, your SDS book. We can conduct that risk assessment for you, give you recommendations, and get you compliant. We can do any post-injury accident investigation, whether or not it's reportable. We could still come and do that for you and give you the root cause and what we can do to make sure that injury never happens again. We can assist you again with OSHA inspections and citations. Any OSHA inspection, if I help you, if I come out and do the inspection, I am not going to charge you for that. I will charge anything if it results in trainings, then we'll charge you a very minimal amount for training your employees. But again, the informal conference, if I accompany you on an informal conference, I'm not going to charge you for that either. Now, some companies get lawyers involved, and that is your right. But I have an in-house attorney here, along with my coordinators have been on. Every one of my coordinators have been on an informal conference in their tenure. Again, it's informal, and it's important that we attend those, and we can settle the case in the informal conference without any further inspections. Obviously, we can conduct trainings for you, safety trainings. Obviously, the pit training, very important. The forklift training, also very important. Every 3 years, it's a requirement by law that you have those. Again, you can always email safety support at groupmgmt.com if you have any questions or if you want some assistance. If you do not have your coordinator's cell phone number, but it's easy to get that cell phone number. Again, use your account manager, and then you can always go to our website at www.groupmgmt.com. So again, do we have any more questions, Andrew? I'm sorry I kind of rushed through the last part of that, just in the spirit of making sure we try to stay as close within the hour as we could.
Ken says, great info. Thank you very much. Folks, I did just want to call to your attention the chat. I've posted some important links in there. There were some great questions about OSHA 300 logs. And so I have included links to the OSHA website that explains who's required to e-file their 300 logs. as well as a link to an explanation of the changes for e-filing for employers with more than 100 employees. I've also included a link to the PDF package for completing your OSHA 300 logs, fillable PDFs that you can type the information into and then print and post. Remember that the posting deadline for that is February 1st. They have to be posted until April 30th. As Paul mentioned, your safety coordinator is an excellent resource. Many of our services do come to you at no additional cost. There is a cost for some, but if there's questions, never hesitate to pick up the phone and reach out to us. If you don't know who your safety coordinator is, you can reach out to safety support at groupmgmt.com. We'll be happy to direct you in the right direction. Does anybody else have any questions? You can post them up here in the chat, and Paul will be happy to answer them for you.
And again, in closing, just to mirror what Andrew just said, we are a great resource. GMS, our safety programs come a long way in 6 years. 6 years ago, it was me and one other coordinator taking care of 42,000 worksite employees. That has since changed, and we have built up our coordinators. We have 8 coordinators as of today. Again, they're required to do 40 visits a month. If you haven't heard from your safety coordinator prior to this, please reach out and introduce yourself to your coordinator. Again, thank you everybody for joining us today. We really do appreciate you, and we do have interest in your safety. As you know, we have a little skin in the game as far as your injuries are concerned. As long as you're a client of GMS, your injuries will stay with us. So again, we do have some skin in the game, and we would love to help. So thank you all very much, and have a great rest of your week.